If you've lived in West Texas for long, or anywhere in Texas for that matter, you know that storm clouds form fast and then rain can fall even faster. Do you know your duties when it comes to rainwater? Do you know what your liabilities are for floods? You're enjoying the warm, sunny afternoon in your backyard when suddenly the wind picks up and sand starts whipping past you. Unexpectedly, it begins to downpour. As you run inside, you notice the water running off your neighbor's property and flowing into your yard. The next thing you know, their patio furniture comes crashing through the fence and into the siding of your house. Now, insurance refuses to cover the repairs, leaving you with nothing but damaged property and a muddy mess. In general, neighbors are not typically liable for harm caused by the naturally occurring rain or land conditions. Drainage from natural landscape is typically seen across land from high elevations to lower elevations. However, if your neighbor has purposefully changed the natural landscaping of their property, causing an increased amount of surface water runoff, then he may be liable. In Texas, regulations and laws make it illegal to cause the runoff of water onto another person's property in a manner that causes damages to the property of another by the overflow of the water. When your neighbor alters the natural conditions of his property through landscaping that causes damage to your property, then you have certain remedies at law and in equity. Typically, this type of activity is considered a nuisance or trespass. Quick plug, make sure to like this video so that way YouTube will show it to more viewers like you. Thank you. Surface water is not defined in the Texas Water Code. However, courts have interpreted it to consist of water falling from rain or melting snow until it reaches a clearly defined watercourse, such as a channel or riverbed. Specifically, the flowing water cannot come from a clearly defined drainage system. If the water is surface water, the most common types of water damage include personal property loss or damage, foundation damage, mold or mildew growth, soil erosion, and health damages. However, this is not an all-inclusive list. If your neighbor is responsible for water damage he has caused, you may be entitled to compensation. This can include payment for the cost of repairs or replacements of items harmed, reimbursement for expenses incurred by flooding, reimbursement of medical expenses, and possibly payments of damages to punish the neighbor if the flooding was maliciously and intentionally caused. Courts may also order the neighbor to fix certain issues caused by the flooding, such as clearing debris or cleaning out drainage areas. The simple answer is insurance. There are two types of insurance that might cover flooding damages: homeowners insurance and flood insurance. Typically, if the damaging water came from an outside source, not within your home or your home's pipes, only flood insurance may apply. You might want to call your insurance company though, as many people think they have flood insurance, but outside source flood coverage isn't typically covered. Additionally, you may be able to collect compensation from your neighbor's insurance company. Be sure to speak with your civil litigation attorney if you need help filing an insurance claim. You may also want to talk to them if you're considering a lawsuit against your neighbor for water damage, as there may be considerations that must be assessed prior to any action. From all of us here at Matthew Harris Law, we hope that you share this video with your circle of friends.